Good evening, everybody, and welcome to another edition of my weekly presentation, Legalese. I'm your Tampa car crash attorney, Chris DeBerry, and this show is going to be a very interesting one. It's going to be a short one, but today we're going to talk about what's coming for all Florida drivers regarding the repeal of the no-fault law in Florida. So if you like what you hear today, smash that like button, but feel free to like or share or comment below. I appreciate your comments and often dedicate entire segments to those comments. In fact, I'm doing that today. Somebody asked me what's happened with the PIP bill, and I'm going to talk about that a little bit right now. So it appears that the PIP bill, which is embodied in Senate Bill number 54, I don't know if you guys couldn't see me, but I couldn't see me. So I kind of had to get out of that and back in. But so Senate Bill 54 has been passed by the Senate and by the House, and it's currently on its way, if not sitting on Governor DeSantis' desk. If the governor vetoes it, then the legislature may have to attempt to override the veto. However, if the governor does sign the bill or lets the bill expire on his desk and pocket veto it, then it will go into law, and that'll be starting in the beginning of next year. So what did Senate Bill 54 accomplish? What did it set out to accomplish? Well, chief among its objectives was to repeal Florida no-fault law. Florida no-fault law or the PIP benefits that are available to Florida drivers. That's one of the things I've talked about in my prior videos many times. Those are the no-fault benefits that pay regardless of who's at fault, up to $10,000 minus your deductible, at 80% for medical and 60% for lost wages combined, up to that total amount of the aggregate, whether it's $10,000 or less if you have a deductible. But that is that would pay no matter who's at fault, and that was Florida's no-fault system, which has been around since 1979 in one form or another. And what was good about the no-fault system was that people were able to obtain health services and medical treatment without having to wait for an at-fault driver to confess liability and pay their policy limit, or having to deal with a case that may be a close call on liability, where maybe liability is shared. In those instances, no-fault benefits, the usefulness of that becomes clear. You'd be able to seek immediate treatment because, as you know, the only obligation that an injured person has under the law is to get well. And PIP benefits and the no-fault system made that possible without too much hassle. Not that the insurance companies didn't try to gum the works up with compulsory medical examinations and peer reviews and things like that, but for the most part, it worked. Oftentimes, the reports of fraud were over-exaggerated, and that's really out of the mouth of insurance executives that even admit that. So no-fault benefits will disappear, and under the new law, what will go into place is a mandatory bodily injury benefit of $25,000, at least 25. You could always purchase more. And bodily injury liability insurance, and I've talked about this before, that's that kind of insurance that you always hope that the driver of the other vehicle who causes the accident or significantly causes the accident is carrying, because that is the fund that would apply to you once your no-fault benefits had exhausted. That would be the fund that we would then go to for reimbursement for your medical bills and for things that no-fault doesn't reimburse for, like pain and suffering, loss of enjoyment of life, mental anguish, pre-accident terror, all of those non-economic damages, in addition to the economic ones, which are medical bills and wage loss, past and future. So now nearly all Florida drivers will be affected by a change in the law such as this one if it goes into effect, if it doesn't get vetoed, if the veto isn't overridden. then by January 1st of 2022, most people will be having a new type of insurance policy. And so what does that mean for Tampa Bay drivers and for Florida drivers in general? Well, I'm going to go through the pros and the cons of this new law as it is articulated in Senate Bill 54. And this is what you can expect. So, like I talked about, what was PIP? Originally established in 1979, PIP basically stood for personal injury protection. And under Florida law, it is required that every vehicle owner or driver on the road basically have $10,000 of PIP benefits to pay. And they're paid by your own insurance company if you're in an accident, regardless of fault. And that was an interesting thing because it provided something for you to pay your medical bills no matter what, as we discussed. Now, under what is likely to become the old law, the minimum of $10,000 of PIP, which would have been primary, meaning it would be the first source of reimbursement, is not going to be there anymore. So you will no longer be filing your medical bills, or your doctor will no longer be filing your medical bills through your insurance company and have the benefit of the fee schedule, reduce your bills and reduce the hospital's bills. Now that's all going away. And apparently one of the things that we had hoped for was that there would be a mandatory medical payment provision in the statute, which would require at least $5,000 of automatic medical payment. It would kind of basically perform some of the function that PIP performed, but it doesn't look like that's going to be something that's going to be mandatory. People are going to be allowed to opt out. I don't know that I would give people the opportunity to opt out of mandatory med pay if I were a legislator, but I'm not the person sitting in that chair making that decision. So what happens if this bill actually becomes law is that Florida will shift from a no-fault system to a fault-based system. So we're going to blame the driver who is at fault for causing the accident, or significantly at fault for causing the accident, in the scenario where that occurs. We're going to put all of the onus on them to be responsible for your medical bills. And it sounds like a good idea. Why not hold the responsible party? Want to put the onus on them. They caused the accident, or significantly caused the accident. They should pay. And while that really seems to be a very easy sell to people, there are good reasons for people to take some responsibility for their own safety and well-being. One, we're better at it than third parties are. If you're at all conscientious and care about your health and your family and your safety, you'll make sure that you have adequate medical payment coverage on your insurance policy. You'll make sure, most importantly, that you carry uninsured motorist coverage. However, mandatory bodily injury, which would be what this new law would introduce, would require that drivers carry $25,000 of a minimum of $25,000 of bodily injury liability to pay for the medical bills, both past and future, lost wages past and future, pain and suffering of the injured person or the person that they injured. So it sounds like a good idea. But there are some pros and there are some cons. And the pros of it would be like what I talked about, that the at-fault party would bear the responsibility for their negligent or even reckless behavior, which you see sometimes in the cases of DUIs and so forth. And I have prosecuted many of those cases in civil bodily injury and also pursued punitive damages on behalf of my clients. So for cases like that, the at-fault party would bear all the responsibility, and the non-at-fault party would not have to go to his policy to cover any of his medical bills, except to the extent that uninsured motorists may cover them. Also, the types of damages, as I indicated, that you can seek under the new system will be more varied. You wouldn't just be able to recover medical bills and wage loss at a lesser percentage, but you'd also be able to pursue pain and suffering, loss of enjoyment of life, and all those non-economic damages as well, provided that the driver that caused the accident carries a policy. They'll bear responsibility for the negligent behavior, provided that they take out a policy. So claims theoretically under this new fault system would be worth more because of the automatic threshold of $25,000. However, there is much to offset from that because hospitals are no longer going to be looking at an automatic reduction on PIP. Neither will emergency room physicians. Neither will really any other provider. They will then be relying upon what we call the usual, customary, and reasonable rate that they charge. And we attorneys will have to be litigating a good deal more and so forth. But of course, this ability to theoretically recover greater amounts of money, because technically, theoretically, all cases will have value, only works if the other party carries a policy. So you see what I'm hinting at here. Everyone needs to have a policy for this to work. And there are certain cons that come with the no-fault insurance going away as well. And one of them is that people that don't carry insurance policies will thwart the whole intent. I mean, currently it's estimated that over 20% of Florida drivers, probably somewhere between 20 and 30% of Florida drivers don't carry insurance at all. So mandatory bodily injury in their case isn't going to make a difference. And Florida is a little bit unique as opposed to other states that have done away with the no-fault system. It's very, very difficult if you live in a tourist-driven state like Florida is to not have a no-fault system. Because in doing that, you're sort of relying upon what people coming from out of the state have in the way of insurance. People from out of the country, they may come to Florida and they may rent a car. They may not take out anything but the minimal insurance on the car. And under what's called the Graves Amendment, you can't sue a car renter unless they're negligent, and you're capped at $10,000 in damages for the minimal damage protection provided under their policy. So this is really rough. And also for people that come from out of state, they may not be carrying bodily injury liability. They may have uninsured motorists for themselves, but may not be carrying bodily injury liability, which is going to help you. So this is problematic. It's also going to increase litigation. And everyone talks about, oh, there's too much litigation. Well, there's going to be more, because right now all of the reimbursement is going to fall upon the shoulders of the other driver. And it's going to create a greater need to sort all that out. We're going to be going at it with the hospitals to reduce their bills. They're no longer going to be under the auspices of PIP and have their bills covered at 75% as they did in the past. People are going to find themselves paying out of pocket for more of their bills than they might have before. So that $25,000, while it sounds good, at that minimum, it's going to get chipped away at pretty much. And people have to realize that. This is likely also going to raise the cost of health insurance. So another con. And as I talked about, the out-of-state and out-of-country drivers introduce a whole different wrinkle to this whole thing. So in my view, maybe a better move would have been to institute mandatory uninsured motorist coverage and maybe accompany that with a $5,000 medical payment non-optional feature in the policies. That way, if the other person of the 20 to 25 to 30% of people that aren't carrying policies at all, and also won't be carrying them when the new law passes, at least if you have mandatory uninsured motorist coverage, then you're protected, because your uninsured motorist coverage will stand in the shoes of the other driver and provide the insurance benefit that they're not carrying if they don't have a policy. So maybe that would have been better. Then maybe a little bit of mandatory medical payment coverage too, to kind of ease that burden, to make sure that you get your treatment right away, so you don't have to wait and possibly get worse and become, physically worse off and become a burden on society, because that's something that's undesirable. So, and this is just a little bit of discussion about this, about what's going to be good about it potentially, what's going to be bad about it, and the cons stack up to the pros. And I think, in my opinion, at least in this attorney's opinion, and I litigate personal injury cases as a plaintiff's personal injury lawyer. Believe me, I love for all cases to have value. I also litigate uninsured or PIP cases as well, and I understand the importance of having those benefits. So right now, the bill has cleared the House and it has cleared the Senate and the House again, and it is on its way to the governor's desk. If Governor DeSantis signs this bill, it becomes law. If he lets it ride, it becomes law. If he vetoes it, it may not become law unless the legislature will override the veto, which would probably have to happen in a new session, because I think the current special session is going to run out in time. But folks, that is all I have for today for you. Kept it kind of short today, but hopefully that information was important. And so when this new law comes out, folks, get with your insurance agent, get with somebody reputable. I like Craig Most of Most Insurance quite a bit. Also, I deal with a couple of other agents that I like a great deal. But you can call me at area code 727-656-7852. We can discuss the new law, and we can also we can talk about people that may be able to provide good coverage, reputable agents, and so forth. So I had a question come from Janet Myers. Will that escalate time frame of when demand is sent to the at-fault insurance company? That could probably cause the need to present a demand sooner rather than later in a case, because the economic damages will rack up much sooner in a case where there's no fault benefit to offset them. So while I concluded this presentation, that's a very important question, Janet. Thank you for asking that. But I do agree that it is probably going to accelerate that whole process and probably cause a lot more cases to go into litigation, particularly those cases where liability is not all that clear between the parties. Of course, those are technically the cases that would get litigated anyway. However, in this case, the at-fault driver, whoever that's determined to be, will not be will be at $1 owing. They will no longer have that $10,000 offset that PIP used to provide, which was sort of the trade-off for having PIP. You sacrificed the ability to pursue non-economic damages without a permanent injury for having the $10,000 in damage. So that offset will go away too, and I guess that's considered one of the pros to some, perhaps one of the cons to others. But folks, that is it. Thank you very much for your for tuning in and listening, and hopefully this information is useful. And feel free to smash that like button, share, comment below, and I hope you have a great week. And God bless and take care, folks. Thank you.